There are three cases where a tenant can force a landlord to pay the tenant's court costs and the tenant's legal fees. The first instance is if there's a breach of the warranty of habitability, and what this means is simply that the house is deemed, or the rental unit is deemed uninhabitable by the court. So for instance, if you were renting a house and the furnace broke in the middle of the winter and you didn't fix it in a timely manner, the court could deem the property uninhabitable and you would be forced to pay the court costs and the tenant's legal fees. The second instance would be if there's a breach of quiet enjoyment. So a tenant has a right to live in his unit peacefully and undisturbed. If you are doing anything to violate that right, banging on his door in the middle of the night, demanding your rent, or just disturbing his ability to live peacefully, you could also be required to pay his court costs and his attorney's fees. And lastly, and the most common, is when the landlord messes up with the security deposit. Okay, when you take a security deposit, it has to go into a separate interest-bearing account, and the tenant needs to have all the information regarding the account. Sometimes landlords will be acting honestly but ignorantly, and they'll take the money and they'll put it into their own bank account. They won't tell the tenant where they're keeping it, or maybe they'll take the security deposit and they'll apply it towards the last month's rent or something like that. If the landlord does it, the court could require the landlord to pay the tenant his court cost and his legal fees. Okay, so be extremely careful when you're drafting the lease, when you're considering evicting the tenant. Keep all of these things in mind, and always consult an attorney. If you want my advice, send me an email, give me a phone call. I'd be happy to explain this stuff further. Thank you.